Okay, so we will be speaking about the free movement of persons. When we say free movement of persons, what do you understand? Which categories are included in the free movement of persons? Yes, Öykü?
Free movement of workers.
Free movement of workers is included. What else?
Free movement of services.
Free movement of services.
EU citizenship.
EU citizenship.
And right of establishment.
And the right of establishment. Therefore, free movement of all these persons are involved under the heading of free movement of persons. But there are certain differences between them, certain similarities as well. As far as free movement of workers is concerned, we said that we speak about a relationship of subordination, that there must be an agreement between the worker and the person and another person under the direction of whom the worker is working and in return receives remuneration. In the free movement of workers, or as far as free movement of workers is concerned, the relationship is a permanent one. Is that true? Yes. And in the right of establishment, is it also permanent or temporary, the relationship? An establishment. That is permanent. The relationship is permanent. The right of, the free movement of services, on the contrary, the relationship is not permanent, temporary. Then we spoke about free movement of workers. We started speaking about Article 45 of the EU Treaty. We said that this provision provides for abolition of any discrimination, direct and indirect discrimination based on nationality between the workers coming from the different member states. We also spoke about the case law of the Court of Justice, that something else is also prohibited, although not provided in the provision. Do you remember what it was? Discrimination, direct and indirect discrimination is prohibited. But what else?
Non-discriminatory measures. I mean,
well, how are they called? Non-discriminatory measures, but which prohibit or which restrict?
Free movement of workers, not depending on the only discriminatory or not.
Exactly, and the example was the Bosman decision of the Court of Justice. But we started with giving definition of the term worker, how it is provided in the decisions of the Court of Justice. Then we spoke about the discrimination and all other restrictions which would have an effect on the access of the to the market is concerned. We spoke about the Bosman decision. Then we spoke about the rights that are given to the workers under Article 45 of the Treaty on the Functioning of the European Union. Today we will be speaking about the restriction or limitation on the public service. Okay, then let's start with let's continue with Article 45 again. Lastly, we spoke about the Bosman decision of the Court of Justice, which provides the obstacles to access to the employment market, even if the national provision is not discriminatory, meaning even if it applies to all the citizens, all the nationals from every member state, then it can still be regarded as a limitation on the free movement if it has got actual effects on the access of the employment market. What was the question in the Bosman decision of the Court of Justice? What was the main problem? Do you remember, or who? Yes, Dennis?
The player, whose name was Bosman, wanted to go to Britain.
Was it Britain?
No.
England? He was playing in Belgium, but
He was playing in Belgium,
he
and
wanted to go to Britain.
he wanted to go to which club? Arsenal. Yes.
Arsenal.
He wanted to go to Arsenal, and
But as long as the club didn't receive the money as a sponsor, it didn't let Bosman to go to England. And then the question was whether it was still the prohibition on the free movement of persons. And we discussed this. The court had that it is a prohibition of free movement of persons. And
was there a discrimination here?
no,
There was no discrimination, but still the Court of Justice found that the rule which requires the payment of a certain amount of money as a transfer fee is a breach of Article 45, because it found that there is this restriction of free movement of that football player. As we have mentioned before, Article 45 of the founding treaty, of the Treaty on the Functioning of the European Union, provides the public services, employment in the public service, as an exception. Article 45, paragraph 4 of the Treaty on the Functioning of the EU clearly mentions that the provisions of this article shall not apply to employment in the public service. In the jurisprudence of the Court of Justice, we realize that the court interprets the term worker widely. On the contrary, it interprets the employment in the public service more restrictively. According to the Court of Justice, the legal designations or the legal definitions of the national legislators of the public service cannot be taken into account by the Court of Justice. Therefore, the national designations as such do not provide for a criterion for the Court of Justice. The Court of Justice makes or applies its own criterion to decide whether a service can be considered as a public service within the meaning of Article 45, paragraph 4. Therefore, the Court of Justice makes its own interpretation to decide whether a specific service can be considered as a public service within the meaning of Article 45, paragraph 4. Therefore, the title, the occupation of the employee, or the public nature of the institution worked is irrelevant for the application of this exception. The Court of Justice mainly applies two criteria that should both be satisfied to find out whether the service is a public service. The first is that there must be a participation in the exercise of powers conferred by public law. there must be an exercise of powers conferred by, given by public law. How would you translate this into Turkish? Exactly. And the duties designed should safeguard the interests of that state. Therefore, a post shall be considered as a public service by the Court of Justice as long as there is an exercise of the power given by or protected by public law, and secondly, as long as it safeguards the general interests of the state. Therefore, as examples, we can give the police, the judiciary, or the tax authorities as that might be considered as public services. The judiciary, yes, the judiciary, the tax authorities, as well as the police, shall be considered or could be considered as public services. On the other hand, for example, nurses or teachers may not be considered as a part of public service. So this has been the provision on the treaty provision on the free movement of workers. Let's move to the right of establishment and free movement of services as they are provided in the founding treaties. As we have mentioned before, the self-employed, in Turkish, the self-employed, bağımsız çalışanlar, serbest meslek erbapları, are granted rights under the founding treaties depending on whether they are established in another member state permanently or on a long-term basis or temporarily. If a self-employed moves to another member state to establish permanently or on a long-term basis, we will be speaking about right of establishment, which is provided under Article 49 to 55 of the Treaty on the Functioning of the European Union. You have the founding treaties. Please read the related provisions, all right? And if the self-employed provides services temporarily in another member state, we will be speaking about free movement of services, which is provided under Articles 56 to 62 of the Treaty on the Functioning of the European Union. When we speak about right of establishment, Article 49 provides for the following rights for the exercise of this right. First, or in other words, right of establishment involves the following rights. First, the right to enter to another member state and stay on a long-term or permanent basis. The right to enter to another member state and to establish permanently or to stay on a long-term or permanent basis. Secondly, to take up and pursue activities as a self-employed person and to set up and manage undertakings. To set up and to manage undertakings. Undertaking? İşletme. Okay. The right of establishment, therefore the right of establishment has got three different aspects. First, right to enter to another member state and to stay there on permanent basis or on long-term basis. Second,
take up and pursue self-employed activities.
To take up and to pursue economic activities there as a self-employed. Third, to set up and to manage undertakings. Therefore, the right of establishment includes legal as well as natural persons. Article 54 of the Treaty on the Functioning of the European Union specifically mentions the application to companies. Persons. The right of establishment was defined in a very famous decision of 89, case 221/89, Factor-Tam decision of the Court of Justice. According to that decision, the actual proceed of an economic activity through a fixed establishment in another member state for an indefinite period of time is considered as a right of establishment. In a decision of 1999, Jenny, the European Court of Justice characterized self-employment as a relationship outside the relationship of subordination. The relationship of subordination would exist in which type of relationship we have mentioned? As regards workers. Here, the relationship would be a relationship outside the relationship of subordination, and in which the remuneration in Turkish, karşılık, earned was paid directly and in full to the self-employed person. In the decisions of the Court of Justice, on the contrary, when worker was defined, we spoke about the relationship of subordination, meaning
There must be special relationship between employee and employer.
there is a relationship between an employee and the employee works according to the directions of the employer, right? There is a relationship of subordination. The worker, the employee, takes the directions from the employer and works according to those directions. And in return, he receives remuneration for his or her services. Here, on the contrary, in the right of establishment, there is no relationship of subordination, and the remuneration is paid directly and in full to the self-employed. In the relationship of workers, who is paid? the employer is paid. Then the employer gives certain amount of wage to the employee. Here, the self-employed is paid full and directly. Okay? In the free movement of services, on the other hand, which is provided under Article 56 of the Treaty on the Functioning of the European Union, the service provided in the host member state does not require permanent residence or any necessity to reside or even any permanent personal or professional presence of the person concerned. The service shall be provided in the host member state meaning, what is that in Turkish? Ev sahibi devlet. Host member state meaning here the member state where the service is provided. Okay, the second member state where a person goes to provide services. According to the founding treaties, under Article 57, services is defined as those provided for remuneration as insofar as they are not governed by provisions related to free movement of goods, capital, and persons. In this regard, the industrial and commercial activities and those of craftsmen, for example, or of professions are included in the free movement of services. This is a very wide category, and it includes, for instance, the banking services, the areas of insurance, finance, or legal services. As far as the modern technology is concerned, telephone, broadcasting, and internet services are also considered under the heading of free movement of services without the need to move from the host member state to provide services in other member states. According to the decisions of the Court of Justice, free movement of services also include recipient of services. Therefore, when we speak about free movement of services, we do not only understand the free movement of service providers, but also free movement of service receivers, okay? It is in the decisions of the European Court of Justice where a distinction is made between free movement of service providers and the free movement of service receivers. For example, in a decision of 1987, in Kovan, the claim involved for criminal injury compensation by an EU citizen in France. In 1993, in another decision, in Commission versus Spain, the Court of Justice provided that the right of EU nationals to visit museums without any charge on the basis of as nationals are also considered under the free movement of services. We spoke about that. Do you remember that the service providers, service receivers includes students, includes patients, for example, and they also include the tourists as a wide category of service receivers, and they also enjoy free movement in the European Union. We spoke about that at the very first hours of the semester. According to the Court of Justice, provision of services may even justify the setting of an infrastructure in the host member state. According to the decisions of the Court of Justice, the provision of services may even justify setting up of certain infrastructure in Turkish, altyapı, in the host member state. In the decision of 1994, Gebhardt versus Milan Bar Council, and we will have a presentation about this decision, the Court of Justice provided that establishment, the right of establishment, as the right of community national to participate on a stable and continuous basis in the economic life of a member state. However, according to the court, the temporary nature of the activities has to be determined not only of the duration of the provision of the service, but also according to its regularity, its continuity or periodicity. The fact that, according to the court, just because of the fact that the service is provided on a temporary basis does not mean that the service provider cannot equip himself with necessary infrastructure in the host member state, as long as such an infrastructure is required for the provision of that service. I will say it again. as long as that infrastructure is required for the provision of that service in the host member state. Okay, what are we speaking about here? You can explain because you will be making the presentation. What is it about?
It's about the distinction between the services and establishment.
Yes, it's about the distinction between the right of establishment and provision of services. Normally, when we speak about right of establishment, we look for
The permanence of the activity.
Permanence of the activity. And on the contrary, for the right of, free movement of services, we look for
The temporary
provision of the service. However, what does this decision say?
But it says that the worker can use like office or chamber.
The service provider?
The service provider can use office and chamber like as an equipment in that host member state to provide service. It doesn't mean that he used the free movement of establishment.
Exactly. For the providing of services, certain infrastructure may be needed. Is that true? Yes. You may need an office, you may need chambers to give service there, to provide service there. Therefore, just because such infrastructure is provided, this does not make it an exercise of the right of establishment. Is that true? It can still be provided on a temporary basis and could be accepted under the free movement of services, even though there is a right of there is the exercise of the free movement of services. Other than these treaty provisions, which you would find more detailed information in your textbooks, in your chapters, please read them. There are also secondary legislation. Today, the most important rights arising from free movement of persons is provided under the Directive 2004/38. This directive is the main and most important legislative instrument on free movement of EU citizens today. It has replaced most of the previous EU legislation, and it covers both the rights of workers and self-employed. This directive is also called as the Citizens' Rights Directive. Or the Citizens' Directive. We will be speaking about this directive in a minute, but other than this directive, there is also regulation of 2011 providing for social and tax rights of the member states. This regulation provides for equal access to employment for all EU nationals. It provides for equality of treatment in employment. and also provides for the children, the rights of education of the children of EU nationals in the member states. Okay, we will be dealing with the Directive 2004/38, the Citizens Directive first. Then, in very short, I will be explaining the regulation. Any questions so far? Good. The Citizens Directive provides for three main issues. First, the conditions for rights of free movement and residence of EU citizens and their families, the family members. Second, permanent residence of EU citizens. And the family members in the member states. Third, limitations of these rights justified on public order, public security, and public health. Before speaking about these rights, let's make sure about the personal scope of the directive. Whose rights are provided here? Whose rights? Any ideas? Yes, Dennis?
EU citizens and his or her family members.
Exactly. First, EU citizens. The rights of EU citizens are provided. Who is an EU citizen? Yes, a citizen of a member state. The citizens of the member states are considered as EU citizens. Do you remember which treaty brought European citizenship, therefore the rights of EU citizens? Yes, the Maastricht Treaty provided for the first time the concept of EU citizenship. There are certain rights of EU citizens in the founding treaty, as you know, in the Charter of Fundamental Rights, as well as in this very important directive, which provides generally. Second, the rights of family members are also provided in this directive. Then the question arises, who is a family member?
Yes.
Who is a family member? Yes, what's your name? Sena.
I think their husband or wife and their children.
Ah, the spouse.
Yes.
In Turkish? Exactly. The family members include the following. First, the spouse. Second, we don't say children. Sorry? Issue?
Yeah.
No?
I saw this in some places they say issue, but
Issue.
maybe that's just a joke.
No, we don't say that. Direct, yes. Say?
Possibly.
Sorry?
Like in medieval European.
No. Second, direct descendants. Direct descendants. Do you want me to write? Direct descendants are under the age of 21 or who are dependents. In Turkish, descendants, altsoy. The direct descendants who are under the age of 21 or dependents, including those of the spouse or partner, as you will be seeing. Wait. Third, the dependent direct relatives in the ascending line. The dependent direct relatives in the ascending line, including those of the spouse or the partner as well. And lastly, 4, the partner. Therefore, the spouse, the partner, the direct descendants who are under the age of 21 or who are dependents, including those of the partner or the spouse, as well as the dependent direct relatives in the ascending line, including those of the spouse and partner, are considered as family members of the EU citizens. We will continue after the break.